Thanks for joining us today on Mormon Land, where we explore news in and about the Church of Jesus Christ of Latter-day Saints. I'm Managing Editor Dave Noyce. I oversee the Salt Lake Tribune's faith coverage. I'm joined by Senior Religion Reporter Peggy Fletcher-Stack. Hi, Peggy.
Hi, Dave.
We remind our listeners about another way to support Mormon Land. Just go to patreon.com, where with a donation as small as $3 a month, you can access transcripts to our podcast, our complete newsletter, and all of our exclusive religion coverage. Again, that's Patreon, patreon.com/Mormonland. Now for today's episode. A multimillion-dollar fraud lawsuit against the Church of Jesus Christ of Latter-day Saints appeared dead and buried nearly 2 years ago after a federal judge threw out the case. But a divided appeals court revived part of James Huntsman's suit this month, flatly stating that, quote, a reasonable juror, end quote, could conclude that the faith's top leaders, including then President Gordon B. Hinckley, misrepresented how they spent $1.4 billion in church funds to build the for-profit City Creek Center shopping mall in downtown Salt Lake City. Did the money come from members' tithing, intended for church and charitable operations, as alleged? Or did it come from the faith's commercial enterprises and, quote, earnings of invested reserves, as the church has maintained? Or are those, in the end, distinctions without a difference? Where does this case go from here? What are its chances? What's at stake for the global faith of 17 million members? And how does it fit into the ballooning media attention on the church's wealth? Here to discuss those questions and more is our colleague, Tribune reporter Tony Semerad, who has reported on this lawsuit since it was first filed, along with a multitude of other stories about the church's finances. Tony, welcome to Mormon Land.
Thanks very much.
First, tell our listeners briefly what James Huntsman's lawsuit alleges and seeks. And we know that James Huntsman, a former member, is a brother of Paul Huntsman, chairman of the nonprofit Tribune's board of directors. So what does James' lawsuit say, and what's he seeking?
So this lawsuit was filed in California, March of 2021 kind of window. James Huntsman, 52-year-old movie media mogul in California, is seeking about $5 million of tithing and investment on earnings on tithing and damages from the Mormon Church, basically alleging fraud. He's alleging that he gave over a lifetime as a loyal member and believes that giving was under false pretenses, that he was misled, that tithing and other kinds of donations like that were used exclusively for church operations and charity. And so basically under California statute, he's claiming fraud and he wants the money back.
Okay.
And so what did the appeals court, the recent ruling?
Well, so James Huntsman's lawsuit was rejected pretty quickly at the U.S. District Court level, and he swiftly appealed to the Ninth Circuit Court of Appeals, and a 3-judge panel from the Ninth Circuit Court of Appeals, 2 of those judges, which is all you need, 2 out of 3, basically overturned the district court judge's basis for summary judgment. The district court judge had ruled that if you agreed to a certain set of facts, which both sides sort of presumed were true for the purposes of summary judgment, would a reasonable juror believe that? And Judge Wilson said no, a reasonable juror wouldn't. And 2 of the 3 at the Ninth Circuit said, hold on a second, a reasonable juror might believe that. And so it's been sent back to U.S. District Court.
What did the dissenting judge of the 2 in that 2-1 vote at the Ninth Circuit, what did he say?
Well, so it's a pretty strongly worded dissent. I believe a Judge Corman based in New York said, well, basically sided with Judge Wilson at the U.S. District Court level, basically saying that if you accepted a basic restatement of what church leaders said and what they did, that a reasonable juror could not find a reason to think that former or then President Gordon B. Hinckley and other church leaders were misrepresenting or lying in a way that would have convinced Huntsman and duped him, so to speak, and proved fraud under California statute.
So remind our listeners again, what is the key thing? As I understand it, it's that Gordon Hinckley said that it was not based on tithing, but on money from other corporate properties.
Yeah.
But also interest on tithing? Did he say that? I guess this is the issue, right?
Yeah. So the original lawsuit draws on 5 different sets of comments from church leaders, including these 2003 statements during General Conference from Gordon B. Hinckley. And just to back up a little bit, to prove fraud in California, you basically have to prove a misrepresentation, that there was
intentional,
a sort of an intentional basis for James Huntsman to have been misled somehow. And so from the pulpit, as you recall, in 2003, talking about the City Creek Center development in downtown Salt Lake City, Gordon B. Hinckley said, don't be confused about this. He meant to be very direct. He said that no tithing would be used on that project, but went on to say that earnings off of investments, and specifically earnings off of invested tithing, would be used, and made, at least in his mind, a very clear distinction between the two, between tithing and earned earnings off of invested tithing. The other 4 statements that were included in the lawsuit did not involve that additional explanation. They were just basically direct statements from church leaders that no tithing would be used. It's only Hinckley that then went on to say where the money could come from. And it's that distinction between tithing and, earnings off investments of tithing that were both the subject of Wilson's decision, at the U.S. District Court level, which basically said nobody can confuse that. Hinckley was very direct. And then the one dissenting judge at the Ninth Circuit Court of Appeals felt Hinckley's statement was very clear, and nobody could have been misled by that. The 2 prevailing judges, however, seemed to say that last sort of qualifying statement about earnings on investments was a little more ambiguous, and their feeling was that in some ways it was sort of apples and oranges, referring very clearly to tithing, but then in a more kind of ambiguous way to where the money would come from. And so it's based on a reading of that statement and those differences that the judges.
So if he had just said no tithing monies were used without that additional, would there be that's sort of in some ways a false statement? Yeah,
it does, right? Raise it is that sort of latter part of it.
That's the issue.
Entered in the court record, and is part of the evidence base that the Ninth Circuit had to sort of base its decision on. But yeah, that's what's created the ambiguity, is the lack, as it were, of a clear explanation as to where the money was coming from, if it wasn't coming from tithing.
Tony, I want to go on that just a little bit more, because you and I have talked about this too. I wish for our listeners, I'm going to read what Gordon Hinckley said at the General Conference. Okay, I wish to give the entire church the assurance that tithing funds have not and will not be used to acquire this what would be the mall property, nor will they be used in developing it for commercial purposes. Funds for this have come and will come from those commercial entities owned by the church. These resources, together with the earnings of invested reserve funds, will accommodate this program. That seems to be carefully worded to get around what the very point of contention is.
Yeah. Well, and the judges at the Ninth Circuit also, well, as did Judge Wilson, also make a very interesting distinction about Huntsman as opposed to just the regular Joe or Jane out there, basically saying that having been inculcated in the church and aware of doctrine, he would have known what that language that Hinckley was using, what that meant.
And being involved in business and knowing much about the business world and large sums of money.
Right. And so it's important to remember that this lawsuit hinges not just on what the average person might believe, but James Huntsman's threshold is that he has to believe fraud in his case, that he was misled by that. So I would agree that it would appear to be a fairly clear statement from Gordon B. Hinckley, but two judges, 2 of the 3 at least, disagreed.
Okay.
So James Huntsman is claiming all his tithing over time should be returned, right?
Yeah.
Not just the year of City Creek or whatever. What does he say were his reasons for paying tithing before this?
Well, those reasons, very carefully enumerated, are much like the reasons that any devout member of the church, the basis for tithing. He recognized it as a sacred ritual, had been assured both directly and sort of implicitly by church imagery and doctrine and that sort of thing, that those monies were used exclusively for operations and for charitable purposes, and specifically not for commercial.
Except most devout Latter-day Saints really don't care what the church does with it's their money.
Yeah,
they do it as a religious discipline.
Yeah,
they don't say, well, I mean, they presume that it's being spent for charitable purposes or religious purposes. But every time we do a story about tithing, members tell us we don't really care what they do with our money.
Yeah, that's interesting.
Makes him distinctly different.
Yeah. Well, so by way of broader context, James Huntsman is caught up in the same kind of almost transformational kind of perceptions of church wealth that's been going on since 2019. His lawsuit was essentially triggered by these claims that most of us are familiar with now by IRS whistleblower David Nielsen, a former employee of Ensign Peak Advisors, the church's big investment arm. These revelations in 2019 that, this vast repository of church wealth had not been spent on charitable purposes, I think have changed essentially the debate on church wealth. And it was really those comments that brought everything into context for Huntsman and prompted his lawsuit. And in fact, an affidavit from Nielsen was included in the record at the district court level. So it's interesting that James Huntsman would seem to represent kind of a different view of tithing, but it does seem to be related to this idea that those funds aren't being used for charitable
he himself
purposes.
Has changed over time, I guess, about his reasons for paying tithing, and if the 2019 whistleblower changed.
He actually stopped, I believe, in 2015 and left the church in 2020.
About the time of the exclusion policy, I think, is
right. And
he has cited.
Right.
So.
And we have other indications through his commitment to donate any sort of settlement in this lawsuit to charitable purposes, and specifically ones supporting LGBT, that he has reacted to that. And he's also on the record as reacting to the church's policy on polygamy too.
Right. Now, Nielsen's affidavit points to this tithing and how those funds were viewed by people who were over those funds. Right. I think what does his affidavit say in regard? Something about that it was all treated as tithing by employees.
It's a fascinating insight into Ensign Peak Advisors culture,
the church's investment
arm's culture, in a way that, according to Nielsen's affidavit and claims he's made in the whistleblower complaint to the IRS, that essentially everybody up and down the hierarchy at Ensign Peak referred to these as tithing funds, whether they were originally surplus tithing or invested funds that, the yield of invested tithing. It was all referred to tithing, according to David Nielsen, and all kind of commingled in a way. And that Huntsman has referred to that very specifically in his lawsuit at the district court level, that, Ensign Peak itself wasn't distinguishing whether this was tithing or not. So why would we believe their distinction? So just to be clear, the two expenditures that are at issue, there was a $1.4 billion expenditure from Ensign Peak for City Creek Center, another $600 million. I'm sorry. Don't forget the zeros.
Yes.
$600 million expenditure on an ailing insurance company, Beneficial Life, was also mentioned in
that the church owned.
That the church owned. That was also mentioned in Huntsman's lawsuit. Interestingly enough, at the Ninth Circuit level, the two judges have decided to wipe away the beneficial life portion of this. There just wasn't the same sort of evidentiary level of, fraud claims related to that expenditure as opposed to City Creek. But the City Creek expenditure now goes back to the district court level.
Let's talk about district court. Now, so the case, at least right now, is going back to what's the next steps?
We have a couple of interesting signals there. The court docket indicates that the church has brought in new attorneys. One's based in Alexandria, Virginia, for what will be a rehearing before the Ninth Circuit. So the church has filed documents. The original case, the 3-judge panel is what's called a panel of the Ninth Circuit court. An en banc rehearing would go before all 29 judges. There's which the church is seeking that rehearing, or at least it's filed an extension.
Indicating that
it will seek that rehearing. There's a very high threshold for that. Has to basically prove major error by the original 3-panel panel of judges. So it'll be interesting to see where they get on that rehearing. And then following that rehearing, it would be remanded back down to the district court, to Judge Wilson in California.
So if it's back at the district court, let's say it ends up back at district court. Okay. Same Judge Wilson's court.
Right.
It goes to discovery, possibly trial. What's at stake for the church in that?
Those are both logical steps. There's a lot of evidence from the church's prior handling of litigation like this that involves church leadership, that the evidentiary stage, the discovery stage, is really a high bar. The church is going to do whatever it can to avoid putting senior leaders on the stand, having them go through depositions. And that's what this evidentiary stage at the district court would involve. It basically goes back to the stage at which it originally went up at summary judgment, and that they were just about to go into discovery at that stage. So it's really going to be up to Judge Wilson what the specific steps are from here. But discovery is next on the agenda.
Why would that be? Why would they try to avoid that? Let's put it that way.
Well, there's every indication from this court record that the church is very skittish about releasing financial information. There's been a substantial amount of this court case devoted to arguments about what should be redacted, what financial information the church has provided to kind of show where this money came from and where it went. They've really set a high standard for wanting to keep most, if not all, of that information redacted and away from the public's eyes. The attorneys in the case and the judge have all been privy to it. So, and we have other signals that they're highly reluctant to release any kind of financial information. So that may be one threshold. Some of the witnesses that submitted affidavits on behalf of the church are relatively highly placed. They've drawn from people in the finance department and that sort of thing. And the church may well be reluctant to,
but not really general authority level, ecclesiastical level right now.
Not at this point. Not at this point. But the remanded case, the case that's been sent down to the district court level, very clearly hinges on these statements from church leaders, and any sort of finding of fact that the court will do will probably involve further input from church leadership as to whether those statements are accurate or not. So,
of course, Gordon Hinckley's not around. So right.
Not around.
Yeah.
And this case is brought against the corporation of the presiding bishopric. And so we could easily see leadership of the corporation called or asked to submit testimony.
Yeah. That kind of leads to a question that I want to ask is many argue that this is a religious freedom issue with grave constitutional concerns. Is that expected to be an issue moving forward? I assume that's some of the arguments the church is making.
Yeah, well, it's been
has made.
It's been absolutely fascinating that up until this level, Judge Wilson at the district court level, the 3 judges at the Ninth Circuit have all ruled that this remains a secular case. That is, the action that James Huntsman is bringing is not protected by First Amendment constitutional protections of religion, and specifically there would be an ecclesiastical autonomy or ecclesiastical abstention, which is sort of a technical way of saying courts need to stay out of certain religious matters. Courts can't be under the U.S. Constitution, they can't be in the business of deciding whether matters of faith are correct or not. It's been ruled secular so far that Huntsman can bring his case without veering into First Amendment territory. But this, there are very strong indications that this could be a turning point, and that the church could start making arguments that indeed any kind of inquiry about tithing, asking church leaders what they were thinking when they spent tithing money, could very easily become a religious kind of debate and question that the court would be precluded from deciding. So the lines are fairly clearly drawn now, but that could very easily change.
Okay, some Latter-day Saints, even faithful tithe-paying ones, have said the problem is the church's lack of transparency on its finances, which is something that you say that the church is eager to continue to kind of shield, all of its doings. But that came especially in the wake of when a Securities and Exchange Commission fine that the church paid because it was failing to reveal the scale or report the scale and scope of its stock holdings. Could greater transparency help the church avoid these kinds of fights on like James Huntsman's?
Yeah, I find that question very interesting. I'm not sure if church transparency with regard to the expenditures at issue here on City Creek and then on the insurance company, if additional transparency would have prevented this particular sort of fraud claim. Right. The church, I think, in Huntsman's mind, was sort of being judged as not being particularly transparent. And this revelation from Nielsen was sort of seen as a shocker. Right.
But except if everybody knew that that's what the church was doing with its excess tithing and it was building surplus and investing in it and things like that, then they would know ahead of time.
Yeah, it could very well have headed this off. I don't know. There isn't any indication that we have more transparency to come, even in reaction to something like this. And I really need to highlight that in this case, there's been a tremendous amount of contention about just very simple numbers regarding the church finances, and the church has gone to exceptional effort to try to keep those secret, to the point where the actual oral arguments before the Ninth Circuit Court of Appeals were closed. Mm-hmm. Attorneys tell me this virtually never happens, but because of this concern about financial information, those arguments were closed. So it's specific to this case, and then I think in the general picture, we don't have much indication that transparency is coming. Would it have precluded this lawsuit? Maybe. Hard to tell.
It's all conjecture, of course, now at this point.
Hard to tell.
Could this lawsuit impact other legal actions against the church, including the one in Salt Lake's federal court?
Yeah,
tell us what those are.
Yeah,
quickly.
That case brought by a woman, I believe in South Carolina,
or North Carolina, like the Carolinas.
Laura Gaddy and a couple of other plaintiffs. She is also suing to recover tithing money, and it's based on a line of argument that's gotten a little bit more entangled in a sort of religious question.
Truth claims, essentially.
Truth claims. Did the church actually believe what it was saying when they sort of convinced these plaintiffs to tithe? Being a Utah case, that's in the 10th Circuit, a Court of Appeals. So anything kind of binding in the 9th Circuit is only... it's only citable by reference. It's not binding, but between the circuit courts. But as we were talking before, this case could very easily veer into religious protection kind of arguments that could then indeed resonate with this other. But
it hasn't been dismissed. I mean, it's still.
A portion of it has been stricken and struck down, and the attorney tells me that they're considering whether to appeal that. But the core answer to your question is this case could have bearing on other tithing cases and on other religious freedom cases, depending on how these arguments at the district court level go.
But that federal court here in Utah also ruled that churches aren't immune from fraud claims.
That's right. That case has also contributed to this sort of precedent that you can bring fraud cases against religious institutions in certain circumstances.
A couple more questions. One is, Tony, what has struck you about covering this?
Well, it's really interesting the status that James Huntsman has within the Mormon Church and the way that has resonated in this case. Even in letters between attorneys in an attempt to settle this before it was filed, both sides have made reference to his sort of long pedigree as a Latter-day Saint. He's, of course, son of John Huntsman Sr., a prominent philanthropist and supporter of church leadership. And this one clearly resonates for the church, given the fact that James Huntsman comes from the sort of background that he does. And there's been sort of an expectation that he would see things more from the church's perspective than I think he does. That's kind of implied in church documents. That's been a really striking aspect to me, that it isn't just any plaintiff. This is a particular, his status resonates with the church in a way, and I think with church members.
So one last question, Tony. This ultimately is not a case about whether the church was right to invest its funds to build a mall or to bail out an insurance company, which is no longer part of it. But it's about whether leaders committed fraud in doing so. What do legal experts say about the chances of this lawsuit ultimately succeeding?
Yeah, well, I would go one step further. It's even narrower than that. It's what did James Huntsman believe and how did he act on those beliefs? A very careful parsing of that aspect of it, of how you prove fraud in California, he still has a long way to go. This is going to be a very challenging thing to prove at the district court level, that he actually was personally misled by these statements, and that he gave these millions. And
that those statements were intended to mislead.
A huge threshold in terms of the proof of this case, that Gordon B. Hinckley actually intended to mislead from the pulpit. And again, not just anybody, but him specifically. He has to prove that was the basis of his tithing,
Tony Semerad, thanks for joining us today.
Thank you very much.
We look forward to your continued coverage. Thanks also to Peggy Fletcher Stack.
Always a pleasure.
And to our producer, Theodora Soder. We remind you that you can keep up on all the happenings in and about the church by subscribing to the Salt Lake Tribune's free Mormon Land newsletter. Just go to sltrib.com to sign up, and we'll talk again next time on Mormon Land.